Welcome, friends. This is a demo of my legal drafting course that I'm going to put online for law students, freshers, legal interns, junior lawyers, or law associates who are willing to master the art of legal drafting. So, let me begin with my presentation. What all is going to be covered? First and foremost, the basics of legal drafting course. As you see in all the books, and it must be a part of your law course and curriculum, there are four basic rules for legal drafting. We need to state facts only, not the law, because judges know it better. Second, material facts. Whatever is connected, relevant to the case, should only be mentioned. Pleading should not state evidence that has to become through your documents later on. It must not be disclosed in the pleadings in the beginning. Last, the fact should be stated in the most concise form. So if you think that writing more and filling up more pages makes sense, no, it doesn't. It has to be very crisp, to the point, and more easier for the judge who is sitting on the case to pass an order, in my view. So you must follow these four guiding principles at all times. Next, what are the exceptions to these four guiding principles? Foreign laws, in case you are referring to something which is beyond the scope of Indian laws, you must state it. Then come if there is a question of mixed laws and facts. There is a thin line of difference between both of them. So for the sake of clarity and convenience, it can be stated. Next, presumptions. Order 6, Rule 13 CPC states not be plead such facts where the onus of proof lies on the other side unless specifically denied. So this can also be taken care of. Last, customs or uses of trade, which hasn't got the force of law, need to be pleaded, because this is something rare which comes into practice. These things can be mentioned. Now, the most important, formatting size. Law student, freshers, students must know how to operate MS Word, because all their drafts, all their pleadings has to be in a fixed format, which is accepted by the registry of the court. Now, I follow the High Court because the lower courts are bound to follow what High Courts do. So, I have written there in my presentation, its margins at the top and bottom of the page shall be 1.25 inches and 0.75 inches. Next, left side and right side would be 1.25 inches. The font shall be Thorndale or Times Roman in size 14 with double space. So I've taken the relevant extract from High Court rules and orders. It is there on the High Court website, but this is the most common followed legal draft formatting size, which lawyers do of high courts, district courts, tribunals, and other commissions like state commissions, human rights commission. So you'll not miss anything if you follow this standard size. Most important, making notes. You get the papers and you just start typing and doing it on the computer. No, it doesn't work. You need to make your notes first. First and foremost, case details. Get the facts and dates straight away on your paper. Timeline, day one to day last, what has happened, how things have evolved. The entire chronology of events should be mentioned. Now, what is the issue involved in the case? The legal question. What's the proposition of law going to be discussed? Names of individual, address, age. It should be there because you're going to prepare the affidavit. So it must be with you. Supporting documents, annexures per story. So naming annexures also makes sense. Annexure will be C1, P1, or A1. So as per the code, as per your convenience, you can select it. Now, jurisdiction, limitation, and appropriate forum of the case has to be discussed first. You can't file a service matter case straight away in consumer court. You need to know what's the law, where the case has to be filed. Either it is the district court or the high court. So you need to have this subject knowledge first before going on ahead with your draft. Now, most important, figure out what reliefs and prayer are there in your case. What are you going to ask to the court? So this must be there. Now, once notes are prepared, stick to the format of the code that you have selected. Double check the dates. That's most important. Spellings of the name, places, and specific things in your petition. because inadvertently, if there is any error later on, it takes a humongous time to change those things. So for once and all, you must write it correctly. Ensure consistency in citing chronology of incidents. Do not jump on in your petitions from one event to another. There should be a link between them so that it is utter easy for the judge to comprehend your case in one go. Let's see the next slide. Okay, let's talk of sequence here. Have a draft outline in your mind before you begin drafting. Get summary of the case from the clients or from the person who has assigned you the case, because they know the best version of the case. It should not be vague. It should not be relevant. It should not be irrelevant. It should be rather precise and coherent. The arrangement should be in one sequence. One para should speak of one idea only, one point only. It shouldn't mix up things. Prefer use of simple language without use of heavy jargons, metaphors, making it less comprehensible. Avoid repetition in your case. Know the formatting style, margins of each code, left and right margins. I've just told you in the beginning. It's 1.5, 1.25, right, left, 1.25 on top, and 0.75 at bottom. So see, I remember it from my heart. Like this, you should know what are the formats to be accepted by the code, what fonts are accepted. Numbering of pages should be there in sequence, and the index it should be mentioned. Spacing between paragraphs and lines of petition is always double space, preferably. Address the parties by name in petition rather than using the same in memo of parties. The draft should spell the correct interpretation of law in backdrop of surrounding circumstances. So as on date, whatever the law is on the point, you must state it. Now, every petition has these 7 things. Now, what are they? 1. Jurisdiction. You need to disclose the court which is hearing the matter has this jurisdiction to hear the matter. Limitation. So whether the case has been filed under limitation or not. If not, move a condemnation on application, which the court, if found suitable, will grant it. Next, court fees. There is a fee for filing a case in the court. So you need to mention that the appropriate prerequisite court fees has been given. Then if you have filed any previous case on the same issue or any other connected matters, you must disclose it. Whether you have availed the alternate remedy available to you or this is the first instance you have come to the court, it must be disclosed. Cause of action, when did it happen first, and now why you have come to the court. There must be a reasoning for it. And last would be miscellaneous, like in case you are seeking exemption of certified copies, condonation of delay, there is a vernacular. If you are not able to comply with any of the conditions stated by the registry, you may surpass it through your miscellaneous applications. But that is the discretion of the court. So these form paras are going to be a part of your petition always. Keep that in mind. Now I'm going to cite must. What is a must for writing drafts? One word for group of words that is going to listen the petition. Short sentences use be used. Mention time period. Use active over passive. Write facts and narrative and lead it to a conclusion. Do not just go vague. Avoid confusing the reader with all facts in one para. Repetition of facts, typographical error, wrong provision under which case petition is filed. In your head note, you usually mention under which section or under article, especially in high courts, you cite it under which section the case has been filed. So take care of the fact. And last, state facts, not law in petition, once again. Now, different courts have different formats, so you must check in with the registry what is the recent developments that have been done for accepting the briefs. So it might help you. Like in consumer courts, they are less rigid, they are more flexible. Whereas high courts, it's a very tedious job. They are very strict with their procedure and what is accepted when drafts are concerned. District courts and on the mild level, they can go with on mildness, not like the high courts. Service matter tribunals, AFT, CAT, they are sometimes rigid, sometimes soft, and they have their set petitions which are there. Now, banking matters in DRT and NCLT, again, they work more on the terms of the High Court, very strict with their prerequisites. Legal notices are to be sent on legal size or A4. You can keep it in mind. Now, for brevity, omit all unnecessary facts, omit all unnecessary details when alleging material facts. Proper attention to language alleging to material facts. For precision, names should be correct. Pronounce he, she, they, be avoided. Do not refer plaintiff defendant by names. Refer them some names throughout. So this is the scope if you're going to avail a legal drafting course from me. And definitely you are going to learn a lot. Since my experience has come through this video, it is a kind of a demonstration to you that how you're going to equip the skills of legal drafting through this course. And last, my number is there on slide. In case you wish to speak to me before availing for the course, do let me know. I'll be there to help you out. So once again, friends, thanks for watching. Looking forward. Thanks. Bye.